Tecson and Mapago VCA. Facts: on March 14, 1977, Sangguniang Bayan of Kamalani Ugan, Cagayan, adopted Resolution No. 95. Soon Saturnino Jhojo sent his agent to the Municipal Treasurer's office to pay the license fee of P285 for thresher operators. Mapago refused to accept the payment and required him to first secure a mayor's permit. For his part, Mayor Domingo Tecson said that Jhojo should first comply with Resolution 9 and sign the agreement before the permit could be issued. Jhojo ignored the requirement. Instead, he sent the P285 license fee by postal money order to the office of the treasurer, who returned the said amount. The reason given was the failure of the respondent to comply with Resolution No. 9. Jhojo filed with the CFI Cagayan a special civil action for mandamus with actual and moral damages to compel the issuance of the mayor's permit and license. He also filed a declaratory judgment against the said resolution for being illegal either as a donation or as a tax measure. The trial court upheld the challenged measure. However, it dismissed the claims for damages of both parties for lack of evidence. The CA affirmed, nevertheless, it found Tecson and Mapago to have acted maliciously and in bad faith when they denied Jhojo's application for the mayor's permit and license. Consequently, they were held liable to pay damages. On appeal, petitioners stressed that they were acting in their official capacity and therefore they should not be liable for damages. Jhojo claimed that the refusal to issue the permit and license constituted bad faith on the part of petitioners. Also, he claimed that Resolution 9 contravened the limitations on the taxing powers of LGUs under Section 5 of the Tax Code. Issue 1. The resolution is valid. Held yes. Ratio: we need not concern ourselves at this time with the validity of Resolution 9 and the implementing agreement because the issue has not been raised in this petition as an assigned error of the respondent court. The measures have been sustained in the challenged decision, from which the respondent has not appealed. The decision is final and binding as to him. We may observe at this time that in sustaining Resolution No. 9, the CA said no more than that. It was passed by the Sangguniang Bayan of Kamalani Ugan in the lawful exercise of its legislative powers in pursuance to Article 11, Section 5 of the 1973 Constitution, which provided that each local government unit shall have the power to create its own source of revenue and to levy taxes, subject to such limitation as may be provided by law. And under Article 4, Section 29 of PD 231, it is provided that Section 29. Contributions. In addition to the above specified taxing and other revenue-raising powers, the Barrio Council may solicit monies, materials, and other contributions from the following sources: monies from private agencies and individuals. That is an oversimplification. The CA has not offered any explanation for its conclusion that the challenged measures are valid, nor does it discuss its own concept of the nature of the resolution. While it would appear from the wording of the resolution that the municipal government merely intends to solicit the 1% contribution from the threshers, the implementing agreement seems to make the donation obligatory and a condition precedent to the issuance of the mayor's permit. This goes against the nature of a donation, which is an act of liberality and is never obligatory. If, on the other hand, it is to be considered a tax ordinance, then it must be shown in view of the challenge raised by the private respondents to have been enacted in accordance with the requirements of the local tax code. These would include the holding of a public hearing on the measure and its subsequent approval by the Secretary of Finance, in addition to the usual requisites for publication of ordinances in general. Issue 1. Petitioners are liable for damages. Held no. Ratio: the private respondent anchors his claim for damages on Article 27 cubic centimeters. It has been remarked that one purpose of this article is to end the bribery system, where the public official, for some flimsy excuse, delays or refuses the performance of his duty until he gets some kind of pabagsak. Official inaction may also be due to plain indolence or a cynical indifference to the responsibilities of public service. The provision presupposes that the refusal or omission of a public official to perform his official duty is attributable to malice or inexcusable negligence. In any event, the erring public functionary is justly punishable under this article for whatever loss or damage the complainant has sustained. In the present case, it has not even been alleged that the Mayor Tecson's refusal to act on the private respondent's application was an attempt to compel him to resort to bribery to obtain approval of his application. It cannot be said either that the mayor and the municipal treasurer were motivated by spite or were grossly negligent in refusing to issue the permit and license to Jhojo. It is no less significant that no evidence has been offered to show that the petitioners singled out the private respondent for persecution. Neither does it appear that the petitioners stood to gain personally from refusing to issue to Jhojo the mayor's permit and license he needed. The petitioners were not Jhojo's business competitors, nor has it been established that they intended to favor his competitors. On the contrary, the record discloses that the resolution was uniformly applied to all the threshers in the municipality without discrimination or preference. The court is convinced that the petitioners acted within the scope of their authority and in consonance with their honest interpretation of the resolution in question. We agree that it was not for them to rule on its validity. In the absence of a judicial decision declaring it invalid, its legality would have to be presumed. As executive officials of the municipality, they had the duty to enforce it as long as it had not been repealed by the Sangguniang Bayan or annulled by the courts. The private respondent complains that as a result of the petitioner's acts, he was prevented from operating his business all this time and earning substantial profit therefrom, as he had in previous years. But as the petitioners correctly observed, he could have taken the prudent course of signing the agreement under protest and later challenging it in court to relieve him of the obligation to donate. Pendent light, he could have continued to operate his threshing business and thus avoided the lucro season that he now says was the consequence of the petitioners' wrongful act. He could have opted for the less obstinate but still dissentient action, without loss of face, or principle, or profit. Franchises PLDT City of Davao. PLDT is liable for the local franchise tax. Section 137 does not state that it covers future exemptions. The grant of taxing powers to LGUs in the Consti and the LGC does not affect the power of Congress to grant exemptions in the future. The only legal effect of the constitutional grant to local governments, in interpreting statutory provisions on municipal taxing powers, doubts should be resolved in favor of municipal corporations.